Hi, good morning, everyone. Thanks so much for joining us. It's really great to have you all here, and we really appreciate you taking the time. We hope that this will be an interesting discussion today. Before we do kick off, I just want to introduce myself briefly. I'm Adrian Roux. I'm a senior associate in the forensics department at ENS Africa. I'll be joined today for the discussion by my colleagues Curtis and Wim from the employment and dispute resolution teams. We will be saving some time at the end to have a Q&A session. So please do make use of the Q&A functionality, and we will get your questions at the end before we do close off today. And for the Q&A session, we will be joined by Steven Powell, Stuart Harrison, and George Niekerk from the Forensics, Employment, and Dispute Resolution teams as well. So the subject of today's discussion is whistleblowers or whistleblowing. It's certainly a very topical subject, and for good reason. I think there's little doubt that without the assistance of whistleblowers, the progress that we've made so far in unraveling state capture would not have been possible. So it's an uncontroversial statement. I think that whistleblowers perform an incredibly important function. And today we'll be unpacking, I think, two key considerations that flow from that important function that they serve. Firstly, how can we capitalize or utilize this functional resource that whistleblowers represent? And secondly, how can we encourage whistleblowers and how can we provide the necessary protection to whistleblowers so that they continue to blow the whistle and to ensure that this very valuable resource continues into the future? So I'm sure most of you or all of you perhaps are familiar with what whistleblowers are, but very briefly, there's no magic in the term. Simply anyone that reports misconduct, be it criminal or an employment-related issue, is a whistleblower. And whistleblowers may make use of a variety of different means, be it anonymous tip-off lines, they may be direct in-person reports to a line manager, anonymous letters. Again, there's no restriction there. And the concerns really can range from the more severe, so corruption, all the way to perhaps less serious governance issues. So if I go back to the first consideration that I raised, which flows from the important function that whistleblowers serve, it's, how can we utilize whistleblowers within the private sector and the public sector? How can we make use of this resource? Because often, perhaps wrongly or rightly, whistleblowers may be seen as an inconvenience in the business. It's a problem that needs to be followed through and resolved, but it's actually also a resource. And it's important to remember that this valuable tool is something that should be utilized. And we do that by investigating whistleblower reports. And it's important to note that, when you receive a whistleblower complaint, it's often just the tip of the iceberg. The particular whistleblower may not be privy to the full facts, and they might not be privy to the extent of potential problems. So it's really vital that a thorough investigation is undertaken to understand just how far does this problem spread. And coupled to that as well is identifying what does this mean to the business, because often there's large amounts of, perhaps let's take fraud, for example, undetected problems in the organization that can be costing the company substantial amounts of money. So it's only through a thorough investigation process that you can understand what's going on here and really get to the bottom of problems. And, I think the key point to convey in this respect is that the problem, if it does exist in an organization, is going to exist whether you investigate it or not. But only through a thorough investigation are you able to understand who is really the wrongdoer here, so that remedial steps can be taken to remove the problem. And this is particularly important for companies that perhaps have a nexus to the US or the UK. And particularly in severe cases of corruption, let's take as an example. Time and time again, the US and UK regulators have emphasized that the availability of certain prosecution avoiding mechanisms, let's call it that, like deferred prosecution agreements, is the availability of those tools is dependent on the extent to which the organization self-reports proactively. So if you don't investigate, you're not going to know what the problem is, and you're not going to be in that position to make use of these valuable tools. Now, a full discussion on things like deferred prosecution agreements is beyond today's discussion. We really could have a full hour just talking about them. And critical, obviously, for companies with a US or UK nexus. But what is becoming clear is that it might be South Africa too. One of the recommendations from Chief Justice Zondo in his Zondo report was that we look at introducing DPAs into South Africa. So it might not be an avenue available to only US and UK concerns. And just to continue the importance of why we do need to investigate these concerns is also there are certain statutory reporting obligations. I'll take the example of Section 34 of the Prevention and Combating of Corrupt Activities Act. That places an obligation on persons in a position of authority to report corruption, fraud, and related offences. And what's quite critical here is that's a personal obligation. So that duty falls to the person in a position of authority, be it a director or a member of executive management. And if that obligation isn't fulfilled, that's potential criminal liability and up to 10 years in prison for the person that fails to report. So it's a very important point to remember. And it's only through thorough investigations that you're able to get to a point where you can determine, is there a reporting obligation here or is there not? And, you know, you can take a whistleblower report, and what's important about Section 34 is it's not just knowledge. The obligation is triggered where there's a suspicion and even where, you know, you ought to know. So it's quite onerous. And the only way to really get to a point of comfort as to whether or not you do need to report is to conduct these investigations. And lastly, I think it's quite clear, but it's important to emphasize, and that's the deterrent function that investigations serve. So, I mean, if you identify, let's take an example of an employee that's committing fraud in the organization, a thorough investigation is undertaken, the wrongdoer is ultimately dismissed, and the case is potentially referred to the police for investigation. Other persons in the organization that may have been tempted to commit similar acts of misconduct are not going to be so eager to do that if they see what happens where where you do engage in such conduct. And I think just related to the importance of conducting investigations is the importance of conducting independent external investigations where necessary. Why this is critical is often what we've encountered is internal investigations into misconduct might be undertaken, culminating in a report with certain recommendations. But the problem with an internal process is it's always going to be vulnerable to critique, that it's biased, that the organization has stopped and hasn't gone far enough. Perhaps they don't want to see certain instances of corruption or whatever it might be. So that's always going to be a criticism. And what we see is often internal investigations are undertaken, but then you get to the point where there are concerns, you're going to then have to refer that externally anyway. So it's a very inefficient process. You sometimes lose time, costs. So in most instances, it's really best practice to refer these sorts of investigations externally. And that's particularly so where we're talking about cases where the US or UK regulators might be involved. They aren't going to place any reliance on an internal investigation because they have no comfort that it's objective. So those are just some key considerations, where there are whistleblower reports that have been submitted that should be investigated. Often it's really crucial that this is referred externally. And also, if I use ourselves as an example, often external firms will have, like ourselves, will have a multidisciplinary team. So myself, Wim and Curtis are also on the discussion and will come in shortly to provide input from their departments. We really collaborate early on. So if there's an employment issue, I can contact Curtis immediately. There's no need to go and get external resources. So having that multidisciplinary team is really useful for conducting investigations such as these. So just very briefly in terms of process, how does this go? What will typically happen is a whistleblower report will be submitted, be it through an anonymous tip-off line or any other method. Often an organization's internal compliance team will then have a look at this report. And this is quite a critical function, this first pass review, because what needs to be done is the internal compliance team needs to look and see who's implicated in this report, because that will dictate who perhaps the report needs to be kept away from. Let's say that the CFO of an organization is implicated. It will potentially undermine the investigation process that's to follow if he or she gets a copy of this whistleblower report early on, because there could be evidence destruction or anything like that. All of those risks which may arise if the report is circulated too broadly. So the initial first pass that a compliance function does is critical. Thereafter, a referral for independent investigation, as I mentioned. And then what will typically happen is, based on the nature of the allegations, these will be extracted, investigation plan will be formulated and then approved by the business. And then once the go-ahead for the investigation has been given, typically what happens is there's an information gathering and document review phase. As early as this part of the investigation, it is possible to start formulating preliminary findings, but that's obviously fact dependent. What will typically happen thereafter is there will be a digital email review process where we will image the mailboxes of the particular suspect and conduct a digital email review. We use a software called Relativity, which allows us to go through hundreds of thousands of emails very quickly and efficiently to identify evidence, which we will essentially use in the next phase, which is the direct subject engagement. So what we typically do is, after we've done the digital review, the document review, we will identify a whole list of either questions and queries or preliminary findings. And this will then inform the next set of steps, which is the interviews. And what we will do here is we either will engage with a broad range of persons in the organization just to get a better handle of the facts and the lay of the land, but we may also proceed with more direct admission-seeking interviews to try and confirm some of the preliminary findings, and where necessary, obviously give the suspect the opportunity to be heard, which is obviously an important component of the investigation. And then once we've formulated our more concrete findings, we will prepare a report. And this is really where the consequence management component comes in. Let's say that we've identified a particular wrongdoer that's cost the business millions of rands. There might be a very legitimate need or want to recover some of these funds from the individual. And this is where we would lean on the dispute resolution department, my colleague Wim and his team, to assist with any civil recovery steps. That particular employee may also, of course, have been guilty of misconduct. So what we want to do there is make sure that we follow a very lawful and careful employment process to make sure we can lawfully dismiss that employee. Because that employee, and Curtis will touch on this shortly, where an employee has cost the business a lot of money, you don't want them to be more of a headache, because you followed an improper employment process in dismissing them. So as I mentioned, various consequence management steps which may follow from the investigation findings, obviously fact dependent, but it can range from assisting with employment processes, dismissal, civil recoveries, or sometimes engagement with authorities. And this can be anything from liaising with the SEPS or the National Prosecuting Authority, or it can be in cases where potentially the business is at fault, engaging with key regulators to manage that process. But what I'm going to do now is hand over to my colleague Wim, who's going to walk through, I think, civil recoveries and engagement with authorities in a bit more detail.
Thanks very much, Adrian. Good morning, all. So just to take a step back, so you've now received the full investigation report, or you've received the whistleblower report. The question that then comes up is, what now? What should we do next? And that is effectively consequence management. And I suggest that what should be done depends on three factors. And firstly, it is the process that was followed. For example, whether the report was done internally or externally, the facts of the matter, and then finally, the stage of the investigation. So let's just quickly take each one of those in turn. So the process followed. Was the report done internally or externally? Internally means if the particular whistleblower reported the matter within the company or organization. If that is the case, of course, the whole investigation process is largely within the company's control. On the other hand, if the report is done externally, i.e. outside of the company, the whole investigation is actually outside of the company's control, and you are really on the back foot. So for example, let's take a complaint concerning fraud. The way you will treat that will largely depend on whether the report was first done within the company or outside it. And I'll come to a few examples a bit later. Secondly, the facts of the matter. That will also depend on what you should ultimately do. I think this is quite obvious, but to give you a simple example, if the report is that the senior manager is a bully who does not treat his subordinates with respect, you of course cannot institute a recovery against that manager. It will all depend on the facts. And then finally, what will be done or should be done depends on the stage of the investigation. So let's say, for example, you receive a very serious and credible report that there had been corruption or fraud within your company. That in itself may cause a reporting duty may arise just by virtue of that report, whistleblower report. So it's often not possible to even wait for a full investigation before a reporting duty arises or before you make such report. Another example is perhaps where there's a report where an employee siphoned off, let's say, 100 million rand, and you know that that employee is about to immigrate, and that employee has sold all his assets in South Africa. You cannot wait until the finalization of your forensic investigation before you take action. You will most probably have to immediately and on an urgent basis approach the courts to interdict that person from dealing with the funds. So those are the three factors that we suggest have an impact on what you should do. And I think the next thing then is what can be done. And then we suggest here, there are effectively three things, I think. Sorry, can we just go to our next slide, please, Adrian? Perfect. So what can be done? We now know what factors to consider to determine what should be done, but what can actually be done. To our mind, you can do one of three things. Firstly, there's a civil recovery. Secondly, you may need to engage with law enforcement agencies and regulators. And then finally, and Curtis will speak to this, is employment-related matters. Let's again take each of these three things in turn. Firstly, civil recovery. This particular example is perhaps best explained by way of a practical example. So we act currently for a listed company against a former executive. And in that matter, a whistleblower reported that the executive in question awarded multiple contracts unlawfully to her family members. And those contracts were worth almost 100 million rand. We say that the contracts were unlawfully awarded because not only did the executive fail to disclose that the counterparties to these contracts were her family, and of course that constitutes a classic case of conflict of interest, but the contracts also ultimately yielded little to no benefit to the company. In that matter, shortly after the employee was fired, she decided to sell all her assets and move overseas, which, as you will appreciate, made the recovery process so much more difficult. However, we were able to attach that employee's pension fund benefit shortly after we instituted proceedings against her, which of course secured our client's claim to a large extent. So just going to our next slide, and the first point in that slide, which is very important, is it's crucial before you institute civil recovery proceedings to know that there's at least something to recover. So put differently, be sure that the person you're going after is not a person of straw, because what does it help to go after someone and in the end of a long and often acrimonious battle, you have nothing to show for it. The second point is, of course, you have to institute civil proceedings. And you'll have to do it, we suggest, most of the times by way of action proceedings, because damages are involved, firstly. And secondly, there will most likely be factual issues at play. So perhaps just shortly the civil process, only in a nutshell. So as you may know, it starts off with a summons. Thereafter, the defendant has 10 days to enter a notice of intent to defend. Thereafter, about a month, you have a plea. Then you have the discovery phase. Then only do you start doing the pre-trial steps where you exchange requests for further trial particulars, have pre-trial meetings, judicial pre-trial meetings. And then if you are lucky, you are in court within 3 or 4 years. So again, it's extremely important to know that there's actually, at the end of the road, you actually have something to show for all your effort, because it's not a quick process. That's the first point. I think the second point, which touches on what Adrian had also mentioned, is it's crucial for us as dispute resolution to be intimately involved from the get-go in all whistleblowing reports. And we say so because we, of course, have to fashion the particular claim. So it's important for us to also have input into the questions being put to the witnesses and the information being gathered, because we'll ultimately use that in order to prove our claims. And now coming to my second point, or second remedy, it's engagement with enforcement bodies and law enforcement agencies. So as you'll appreciate, whistleblowers often make reports of criminal conduct. For example, fraud, corruption, theft, insider trading, and so forth. In these instances, a civil recovery is not always possible, but even if it is, you will most likely have to deal with other regulators and agencies too. This, as I've already briefly elaborated on already, depends on the facts of the matter and, of course, whether the report was done internally or externally. So if we continue with my listed company example, there the unlawful awarding of contracts also constituted fraud. So we had to assist the company to lodge a criminal complaint with the DPCI, the Directorate of Priority Crime Investigation. And we, to this day, have to constantly follow up with them and engage with the prosecutor of the National Prosecuting Authority to ensure that the matter is indeed thoroughly investigated and ultimately prosecuted. It also often happens in our matters that we don't have all the information to prove or to conclusively find that there had been fraud. So what we ordinarily do is we will lodge a criminal complaint or a query with the South African Police Service and request that they use their powers in terms of the Criminal Procedure Act, and in particular Section 205, to subpoena details and records in order for them to establish whether or not there was indeed criminal conduct. So in that way, we also work together with law enforcement agencies. And perhaps another example of how we work with enforcement agencies is in another matter where we act for a state-owned company, which had also unlawfully awarded several tenders as a result of which several kickbacks were paid to top officials. And those tenders were worth billions of rands. Those unlawful tenders and kickbacks were reported by whistleblowers, and that led to the SIU, the Special Investigating Unit, to investigate those top officials and people within our client's company. And what ultimately happened is we worked together with the SIU and sometimes even acted for them in the recovery proceedings. During that process, we also had to engage with the South African Reserve Bank and the South African Revenue Services, because, of course, these matters inevitably have tax and exchange control issues relating to them too. But it also sometimes happens that we have to work against enforcement agencies. So, and this is perhaps again best explained by way of a few examples. The first one is of a client which is an equipment manufacturer who sold equipment to a government department via a third party. And this third party in turn paid bribes to officials in the government department in order to secure contracts. An employee of this third party then reported this whole scheme to both the public protector and to the Hawks, the DPCI, and alleged that our client knew about everything. So there we had to immediately engage with both officials from the Hawks and from the public protector in order to clear our client's name, whilst the underlying forensic investigation had to run its course. Perhaps a second and last example before I give over to Curtis, and that example relates to this whole Steyn debacle. In that matter, we acted for one of the recipients of that infamous text message which Mr. Marcus Jooste, the erstwhile CEO of Steyn, sent to a few of his friends and acquaintances on 30 November 2017, a week before Steinhoff's collapse, in terms of which he encouraged those recipients to sell their shares immediately. In that matter and in matters related thereto, we had to engage with the JSE, the Johannesburg Stock Exchange, the South African Reserve Bank again, and the Financial Sector Conduct Authority too. So I think I've covered all of those regulatory bodies and enforcement agencies. The point is just that a whistleblower report can have severe consequences and often means that you have to engage with people outside of your firm or company as well. But aside from civil recoveries and aside from engaging with regulatory bodies and enforcement agencies, there are, of course, also enforcement of employment consequences. And it's on this note that I then hand over to my esteemed colleague, Curtis.
Thanks very much, Wim and Adrian earlier. Good morning to everyone. So I'm going to briefly explain two ways in which we deal with whistleblower complaint from an employment perspective. Some of you, if not all of you, may have dealt with this in the past, but I'll start with the most typical scenario. Usually an investigation report that Adrian alluded to earlier from a whistleblower will identify evidence of misconduct committed by one or more employees. And it's important to note that from the start of this process, from an employment perspective, it's important to ensure that the whole process followed in respect of the employees is done in a procedurally and substantively fair manner. Of course, when you've identified the so-called wrongdoers or the implicated employees, one of the first questions to consider from an employment perspective is whether to suspend the employee. And again, you've got to build in the procedural and substantive fairness elements from the moment you consider suspension, because you have to try and, to the best of your ability, limit any risks down the line from an employment perspective, considering whether you're going to have a CCMA dispute later on or even a labor court dispute. And it all starts with how you deal with the implicated employee from the very beginning. Of course, if suspension is required, there are obvious benefits to that. It assists the employer to conduct investigations even further into the alleged misconduct, and strictly speaking from an employment perspective. And typically this is a collaborative exercise between the various disciplines within the firm. As Adrian mentioned earlier, usually our forensics teams will be involved because there have been a series of interviews that have been conducted with various employees and or the whistleblower. And we are exchanging information and assisting each other in dealing with the interviews and just getting some of the evidence as a result of the whistleblowing complaint. Now, of course, throughout this process, if this employee is on suspension or the employee is on suspension, you want to make sure that you've, from an employment perspective, ensure that this suspension has been done fairly. The employee is given ample time to prepare if the employer decides at a later stage to institute disciplinary proceedings against the employee, that everything done prior to the disciplinary hearing has been done substantively and procedurally fair. Of course, the assistance that can be given from a service offering is preparing the employer or the business for the disciplinary process, because once again, it has a domino effect into what will lead later on. And usually it's a CCMA dispute, referral, or a labor court dispute. And so it's very important that from the beginning, of the whistleblower complaint, a fair process is followed throughout. The second sort of scenario that you'll get out of a whistleblower complaint is where the employee themselves has made what we call a protected disclosure, which some of you are familiar in terms of the Protected Disclosures Act. And of course, there's implications in regards to the way that you deal with an employee who's made a protected disclosure. Of course, the Protected Disclosure Act has sets out criteria of what is a protected disclosure and to whom a disclosure is made. And of course, Adrian touched on it earlier, or Wim, that if a disclosure has been made to the employer, the benefits are you can handle it internally as opposed to it being made externally where the process may be out of your hands. And so I'll touch on this later about the importance of ensuring that employees are aware that they can make disclosures or make whistleblowing complaints within the organization for obvious reasons from a consequence management perspective. We touch on the fact that, when you're dealing with protected disclosures, it's important from a procedural fairness and substantive fairness element to ensure that any employee who makes a protected disclosure is not subject to an occupational detriment, which is set out in the Protected Disclosures Act. And of course, there's a hand-holding exercise that we normally give our clients to ensure that an employee is not subjected to an occupational detriment. For example, dismissing the employee, or typical examples of harassment or intimidation because employees come forward and disclose certain information about the business or other employees implicated in the business. Very briefly, the Protected Disclosures Act in Section 3 states specifically that an employee may not be subjected to an occupational detriment. So from an employment perspective, you want to try and protect the employee if they've made a protected disclosure and have reference to the Protected Disclosures Act from the very beginning, because it's important to make sure you have a watertight case, so to speak, from the very beginning or when a disclosure is made by an employee. Moving on to our next slide, of course, the service offering, and Adrian and Wim have touched on this previously, that from an employment perspective, once an investigation report is underway and we've identified that there's certain employees who are implicated, we can of course assist with gathering, collating all the relevant information. And again, this is a collaborative exercise. We recently had a matter with a client who's a listed company, and there were various allegations against the senior executives within the company. And the process of gathering and collating that information can be strenuous because it's considering relevant evidence. It's making sure that your preparation leading up to the disciplinary process is in order. Of course, your evidence is critical, and putting the charges or the complaints to the employee at a later stage. And of course, you sort of stand and fall on the evidence that you prepared from the disciplinary hearing, because later on you're preparing yourself for a CCMA or a labor court dispute. From a pre-disciplinary hearing process, we can of course assist with drafting, formulating the disciplinary complaints. This is a key part of the process. The charges are what you sort of stand and fall on, and it's how you proceed against the employee and to try and find them guilty of the conduct, either as a result of the investigation complaint or the whistleblower complaint or the protected disclosure that's been made. We of course assist with preparing the bundles, liaising with witnesses, preparing witnesses for the disciplinary hearings so that they're prepped and ready to go. And of course, no one ever wants to have a hostile witness in a disciplinary hearing or a CCMA or labor court dispute. And so it's of course important to make sure that those steps are taken thoroughly from the pre-disciplinary process. Also, with the pre-disciplinary process, there's very often we liaise with expert witnesses. We had a recent matter with the client again. We had to liaise with expert IT witnesses. We had to liaise with independent auditors and accountants. And so this process is very important in the pre-disciplinary hearing process when you're dealing with a whistleblower complaint. And I'll reiterate this again. There's always a collaboration between the different departments. We're always collaborating with our forensics team and our dispute team when we're collating all this information and preparing for the disciplinary hearing. And finally, if you reach the disciplinary hearing process itself, there's obviously the service offering that we can provide. either assisting the client by chairing the disciplinary hearing or by representing the client if and when legal representation is granted in the disciplinary hearing stage. Moving on to the next slide. The biggest question for now is how do we encourage and protect whistleblowers? It's important to realize that they obviously perform a vital function within the business. I think we've seen this both in the private and the public sector, that when a whistleblower complaint is produced or there's a protected disclosure, the benefits are that it exposes improper conduct within the business or criminal and fraudulent activity, and it ultimately reduces the company from being exposed to further legal or financial risk or loss. And most importantly, it assists the business to sort of dismiss those employees who are not acting within the best interests of the business. We always say and advise the clients, one way of encouraging employees or whistleblowers to come forward is through your policies. Your policies are the way that clients or organizations communicate to the employees the standards and practices of the organization, the business. And it's important that these policies are in place to communicate how whistleblowers are treated, who they can report to, what are the mechanisms available, and one of which is most important is sort of the anonymous tip-off lines that you would have, so the employee feels and knows that if they make a disclosure or if there's a whistleblower complaint, they won't be subjected to harassment and their identity will be protected throughout that process. And of course, it comes back down to the way in which policies are drafted, training and development that happens around this topic, so that there's awareness within the business about how these whistleblowing complaints and protected disclosures are dealt with from a practical perspective. Moving on to the next slide, we obviously emphasize with clients that your internal policies must be consistent with the Protected Disclosures Act for obvious reasons, as I touched on earlier. It's just to ensure that critically you don't subject employees to occupational detriments. That can lead up to other disputes that may be lodged against the employer, which obviously results in further risk to the business. So you can take those preventative measures early on, from firstly drafting thorough policies, communicating and training employees, and offering that sort of protection to them when the business is faced with those type of scenarios. Taking steps to safeguard and the identity of whistleblowers, very key component. Most employees are worried that if they make a disclosure, as you'll know, their identity will be disclosed. And we've seen other matters in the media where employees have had their lives threatened and their security threatened by implicated employees, and they've been hits made on their lives because they've come forward and they've been brave to disclose or to lodge a whistleblowing complaint. There's considerations going forward, I'll touch on this in the next slide, about how to protect employees who make protected disclosures. Our president has called for tighter laws on this policy and policies to protect whistleblowers or employees who make protected disclosures. You would have seen, as Adrian touched on earlier, that the Zonda report recommended amendments to our legislation to enhance whistleblowing. We've seen in the public sector how rife fraudulent activity is. And I think it speaks to the psyche of an employee to know that if there's protection, that they can come forward and expose fraudulent activities. This equally applies to the private sector, of course, where most of our clients operate in, to make sure that there's an awareness around this topic. One of the ways to, of course, encourage whistleblowing, and some suggestions are incentives for whistleblowers. Now, we obviously don't want to use this as an opportunity for employees to request higher remuneration or salaries, but it's more about ensuring that they understand that there's a reward attached for their bravery. Whistleblowers take a risk on their career, they take a risk in their personal being when they come forward, when they expose information that's critical to the business. And we should look at ways of how to deal with it. How can we incentivize whistleblowers? If it's not remuneration, would it be promotion? Would it be acknowledgement within the business to a certain extent that protects the employee? But these are some of the ways that we should think around incentives for whistleblowers. Of course, another thing would be immunity from criminal or civil proceedings, from honest disclosures. That goes back to the Protected Disclosures Act. If the disclosure is a disclosure in terms of the PDA, there should be some immunity and protection for the employee involved. And of course, if it's an individual who's made a whistleblower complaint, there should be consideration about how they can be protected by providing immunity to that extent. And so, of course, just a brief summary, from an employment perspective, there are various factors to consider throughout the whole process from the very beginning. And these are interlinked to the investigation report, to the procedural and substantive fairness requirements that should be followed, from a suspension factor going through to a disciplinary hearing. And we always advise clients that these steps are critical, because in most cases, when there's a serious allegation or serious allegations against employees, or there's been a protected disclosure, you're leading towards a CCMA or labor court dispute. And so there's an important element in ensuring that procedural and substantive fairness is followed throughout the process to limit any further risk from a dispute purpose factor going forward. And on that basis, I think we've just touched on just a bit of a summary on the process and the future going forward for whistleblowing. Thanks, Adrian.
Thanks so much, Curtis and Wim. I think we'll now move on to some questions. I do have a question to kick off, and I think this is probably best placed for you, George. And that's, in instances where employees have committed bribery or other forms of corruption, what are the rules surrounding the attributing that liability to the business, and what's the risk there for businesses?
Thanks, Adrian. Yeah, there is a significant risk, and of course, the prosecuting authority will often want to make an example of the company rather than simply going after the individual. In terms of Section 332 of the Criminal Procedure Act, the conduct of the employee of the company can be attributed to the company. It's effectively similar to vicarious liability. So that's a real risk for companies. It's something one's got to deal with very carefully to effectively show that the individual was doing it for their own benefit. The difficulty arises, Adrian, that often the fortunes of the employee are tied to that of the company. So Wim and I are dealing with a few matters where huge contracts are awarded, and there are benefits, commissions earned by the employee who secures the contract, but the company benefits. The company benefits too, and unknowingly that the contracts had actually been secured by corrupt means. And then it's difficult. The short advice I have is to try and work as closely as possible then with the law enforcement agencies and try and explain to them that the company was as much a victim, that the company was innocent and ignorant of the wrongdoing, and try and stay on their right side. And if needs be, there may well be a need to make some reimbursement, some recompense. The consequences, if the company is prosecuted, can be horrendous for the company.
Thanks so much, George. Then I've got a question which I think is probably best directed to Stuart. The question is, whistleblowers must not be subjected to occupational detriment. But what happens if, in the course of conducting the investigation, you actually establish that the whistleblower was also involved in the wrongdoing or committed some other misconduct?
Yeah, thanks. So it's interesting. We've dealt with that quite recently for another client. The whistleblower protection does not give blanket immunity to the whistleblower from any accountability in relation to their own conduct. It protects them against retaliation because they blew the whistle. But if you discover during your investigation, typically this is how it arises, that you now investigate the issues that the whistleblower has raised, and in the course of the investigation, you actually discover not only what was going on with those issues raised, but that the whistleblower, him or herself, has committed misconduct. Now, they're not protected against action and disciplinary action for that misconduct. And you need to be very careful that you deal only with their misconduct and don't allow any blurring between what they did and amounting to misconduct and the fact that they blew the whistle, and you can expect that the employee will try and resist any disciplinary action on that misconduct that was discovered by alleging this is really retaliation for whistleblowing. And that's a very fact-specific inquiry to make sure that you can demonstrate with reference to timing, with reference to what you discovered and the validity of the misconduct allegations, that your disciplinary action against the whistleblower is only because of their misconduct discovered and not because they blew the whistle. And you show that through those methods and showing that you took the allegations seriously, you investigated, and you acted upon them if it was appropriate to act upon them.
That's perfect. Thank you, Stuart. And I think then, Steven, I'd like to just bring in some practical examples. Obviously, you've got a wealth of experience, but can you perhaps just share an example of a whistleblower success story? You know, a whistleblower reports something and there's a happy ending.
Yeah, no, absolutely, Adrian. We've done a multitude of cases which have emanated from a tip-off that the company itself would have had no idea about. And in fact, in many instances, the companies were bleeding and totally oblivious to the fact that they were losing money in terms of procurement spend. And the best example is this huge investigation we did a few years at the Hillstar Maintenance Depot in Ottery, where we got a tip-off from an informant, and it actually led to us doing a major investigation with the Hawks and the asset forfeiture unit getting involved, and it led to a recovery of several million. But the most important thing to share with the audience today is that this tip-off resulted in 12 employees being dismissed out of a workforce of 30 at the depot. And there was massive collusion. The organization had had clean audit year after year based on the comprehensiveness and good record keeping that they kept. But the record keeping was fictitious. It was all fake documents and people were signing for fictitious deliveries, etc. And we were able to quantify and prove fraud to the value of 2.5 million in terms of the supplier who was paying kickbacks to different staff members, and the same parts were being round-tripped. But the real value came in cleaning out the rot. We got rid of the dozen employees out of the 30, and we used the junior employees as witnesses against the main culprits. And we went criminal with this matter. We ended up getting 10-year jail sentences against the supervisor, 2 supervisors, and the director of the company paying the bribes. And none of this would have happened without the whistleblower. It also had a sad ending because the whistleblower didn't tell us at the time that he was complicit in the kickbacks. And when we identified that, he was one of the 12 that was dismissed. And he said to me, "Mr. Powell, this is grossly unfair. How can you fire me? I blew the whistle." And I had to explain to him, "Sir, you didn't tell us that you were complicit, and you need to understand when you admit to acts of dishonesty, you have breached the trust relationship with the employer." He wasn't happy, took the city to CCMA, and the CCMA ruled against him. And I said to him, "Sir," and I'm not going to reveal it, I almost revealed his name. And I said to him, "Sir, you need to understand you could have gone to jail for this, and we're grateful for your intervention. But, the reward you got was that you were not imprisoned for complicity in this fraud." But the worst part of all of this, or the best part, I should say, is that the spend at the depot after we removed the rotten apples who were all highlighted by the whistleblower was that the spend dropped from 22 million per annum to 14 million per annum on spare parts. And this syndicate was in place for years. So it just highlights just how invaluable these whistleblower tip-offs can be. Thanks, Adrian.
Thank you, Steven. I've got another question for you, Stuart. I'm going to paraphrase the question, but it's something that I think, we've worked on a matter recently dealing with this exact issue. It's how do you strike the balance between suspending or deciding to suspend a suspected wrongdoer whilst the investigation is still underway, particularly where it's foreseen that the investigation might go on for some time and there might be media reports associated. So how do you balance that? How do you decide when to suspend and whether it's in the best interest of both the company and the suspect?
Yeah, it's a tricky balance, and there's not one size fits all to this, and it really depends on the particular facts. But the most, in my experience, is that employers are generally quite quick to suspend, probably quicker than they should be. In each suspension decision, you've got to decide what's a suspension about. Is to say, well, there are serious allegations against you, employee. We don't know if they're going to be proven or not yet. But while we are determining whether they are proved, because if they are, then that's very serious, we think you should be removed from the workplace. Why? It's really risk mitigation, because we think you might interfere with the investigation that's ongoing, because you have access to records that need to be investigated, or you have influence over employees, or it'll depend on the particular person's role and how influential they are in the business. And we don't want you there to interfere with the investigation is the one category of reason to suspend. The other being, well, if these allegations prove to be true, we can't allow you to continue to perform your function, whatever it is, because you may then repeat the same alleged misconduct. So those are the factors that you then look at as the employer. So to weigh that up, how big are those risks in real terms versus the downside to me as the employer is I have a person sitting outside the workplace whom I have to pay while they remain on suspension, a precautionary suspension, and I may take a long time to complete my investigation. And you weigh that balance up. And I think in some instances, and I think I'm starting to see a little bit of a trend. It's too early to say that it's a trend, I guess, but some signs of employers being a bit more circumspect about pulling the suspension trigger quickly. Engaging, look, this person really can't do any harm because if we've got the external investigators in who've imaged the hard drives and who've taken possession of the email records and people can be closed off from access to company systems, then you can often reduce that risk considerably and then leave them in there and carry on. And obviously you have an incentive to finish your investigation more quickly, but there are going to be cases where that's not so, and that you need to get the person out to. And especially when things like bullying or intimidation is part of the allegations, to allow the freedom for the other employees to cooperate with the investigation. But I think the problematic cases are mostly in the public sector, where investigations seem to take years. People are on suspension. If you see that in the media all the time about the amount of civil servants who are on suspension pending investigations for years and years and how much it costs. I don't think that's a problem with the suspension per se. It's a problem with the inefficiency of investigation. That if most private sector companies accountable to shareholders who are looking for returns on their investment will know they need to get their investigation done promptly and efficiently, because otherwise they've got to explain these people sitting out there on suspension. So I think the problem is the capacity to investigate and successfully conclude investigations, to then bring the suspension to an end. Either the person goes back to work because they are not guilty of anything, or they get dismissed for serious misconduct. And the other thing is why long suspensions can be a sign enough that there's no real grounds to suspend or ammunition against the person. And I say this in public sector context mostly, because if there is, you act on it. You don't sit for 2 years, twiddling your thumbs and trying to dream up a reason why you can get rid of them. That's a common feature, I think, of these long suspensions. But I think that's a public sector issue more than a private sector issue.
Perfect. Thank you, Stuart. Perhaps we could just jump back a couple of questions. We spoke about providing adequate protections to whistleblowers, and specifically the Protected Disclosures Act refers to disclosures made in good faith. How do you go about understanding whether a complaint was made in good faith, and what's the concept? What does the concept of good faith mean, and how do you assess it?
Yeah. Also difficult, in fact, specific. One's got to look at the merits of the particular complaint and why the person why they have the suspicion they say they have, or whether there's a reasonable basis for it, whether there are other factors which might be the real motive for the complaint, and the complaint lines and whistleblowing can get abused. You know, it's like any process. If somebody's got an axe to grind against their manager or their, you know, supervisor, and they said, I'm going to make life difficult for this person, I'm going to dream up a complaint and they're going to get suspended. That happens. So one's got to tread carefully because of the protection, legitimate protection that whistleblowers enjoy. And in many instances, you're not going to be able to prove that it's not bona fide. So you want to assess is on what basis do you arrive at this suspicion that this person might be involved in this form of misconduct, misbehavior, fraud, corruption, and the like. We have had instances, and most of the policies that we do will specify in the policy that this is for genuinely held beliefs. You know, if we want what's bona fide about a complaint, is if you genuinely hold a suspicion or belief on grounds that are rational, they may not prove to be correct, but there are reasonable grounds to hold that belief that this person may have been involved in misconduct, then you're well within the bona fides of the requirement. But if you make it for ulterior motives, you don't actually suspect at all that the person's, you know, done anything wrong, but you're doing it to get back at them for some or other reason. And I've had a case where we've successfully fired a person, where we could show on the facts, and you've got to have very good and careful facts. This was just a vendetta. It had nothing to do with any, you know, bona fide belief that the person has done something wrong. They just wanted to make life difficult for a person. And, you know, if there are multiple complaints from the same person, all of which are unsubstantiated and can't be justified, you know, then you start getting into territory to say, well, you're actually abusing the process. And I think ultimately, you know, if you make a serious false allegation against somebody through a whistleblowing lie, but knowing it to be false for ulterior motives, that's dismissible in my book. And we've seen dismissals upheld for it. But you got to be very careful with your facts.
Perfect. Thanks, Stuart. I think we've got time for perhaps one last question or theme, and I'd like to direct that to Steven. Perhaps you could just provide some practical examples or more detail on how we can protect whistleblowers.
Certainly, Adrian. The first caution I want to give to clients on this session is that it's never a good idea to try and investigate who the whistleblower is. I can't tell you how many CEOs have asked us to do exactly that, and you really are going down a rabbit hole that is going to backfire. And you need only look at the Barclays case to see what happened when that route was followed. But how we protect whistleblowers practically when we do these investigations is we have to understand that in many of these matters, the investigator is subjected to potential physical harm. So we try to keep the whistleblower anonymous. And as an investigative team, we try to use the info from the whistleblower and then pretend we're that smart that we find the problem ourselves. And as long as we keep whistleblowers anonymous, we do manage to protect a lot of whistleblowers. We've done investigations into syndicates where the whistleblower is the right hand of the bad guy and he has no idea. And if he finds out, that whistleblower could be taken out. So we must be mindful of the dangers. And then for clients as well, just be careful on how you deal with communications, etc., because sometimes the fraudster or the culprit will know exactly who the whistleblower is just from documentation, wording, etc. So be sensitive that we don't inadvertently tip off people that may put the whistleblower at risk. It's that type of protection, Adrian. It's a very practical type of approach that we try to follow.
Fantastic. Thanks so much, Steven. I think we've now reached the end of the session. I just want to say thank you so much again to everyone that's participated and joined today. It's obviously an incredibly topical and important subject, and it's in everyone's interest that, you know, you're firstly fully aware of what the law is and what steps you can take to continue to protect whistleblowers so that we can make use of this valuable resource going forward. But thank you so much, everyone.